Welcome to Condo Insider on Think Tech Hawaii. I'm your host, Na Lan. Joining me today is our guest, attorney Matthew Evans, my law partner at Damon, Leong, Kupchak, Hastert. Matt specializes in litigation, dispute resolution, and appeals involving business and commerce, construction, creditors' right, insurance, and real estate matters. He has been recognized in the 2023 edition of the Best Lawyers in America for his work in litigation, construction law, and real estate law. Matt is recently nominated to serve as a board director with Meritas, which is an established worldwide alliance of more than 180 independent commercial law firms with a collective presence in more than 240 global markets. As part of his practice, Matt has represented condominium community associations, property management companies and managers, association directors and officers, and unit owners. Today, we have the pleasure to talk with him about dispute resolution options and strategies for condominium associations. Welcome, Matt.
Hi, Na. Thanks.
Yeah, so as you know, our main audience for this show is especially new board directors and property managers joining this industry. So for their benefits, what are the typical disputes a condominium association could be involved in? As we say, if you can identify conflict early enough, you can try to prevent those. Mm-hmm. So what are the most common types of disputes we're dealing with?
Well, it's a good question. And I think that particularly for maybe a new board member, maybe this is your first time you bought a condo in a new project or it's your first home and you're not familiar with this way of living in terms of living in a condominium regime. You might kind of be thinking, hey, it's cool. I want to join this board. I want to have some say in the direction of my community that I live in, whether it's a high rise or a sprawling type of community. You may not even think, you might kind of be thinking to yourself, what kind of disputes would even happen, right? We're making decisions about paint color, right? Or like how to maintain the pool or whatever. But the reality is that as you and I both know from being lawyers and practicing in this area, is that it is replete with disputes, this area of industry in Hawaii, and it is big business. I mean, we live in Honolulu, particularly, we're seeing more and more condominiums come up. And with the continued prevalence of condominium living, we're going to see more and more disputes, unfortunately. And so that's the reality of grouping together in high numbers and deciding to be neighbors with one another. And so if you're a new person joining a board, or if you're a property manager kind of just coming into the business and thinking, I want to try to be a managing agent as part of this industry, it's important to think through what types of issues and disputes you may be facing, because if you're not aware of the landscape, then how are you going to try to effectively resolve them? And so just based on my experience, I kind of think of, and there's more disputes than just these three categories, but generally speaking, I've found that disputes that associations face tend to be categorized by three types of different things. The first is kind of the most obvious, I think, which is disputes with homeowners. If you're a condominium association and you have 400 units in a high-rise building, you have 400 neighbors that are all trying to live together, and inevitably someone is not going to be happy at some point and is going to have a dispute, whether it's about construction of a house rule or a violation that they received for speeding in the parking lot, whatever it might be. Homeowner disputes are very common. So it's important to understand how those arise and the available means to try to resolve them. The second category I tend to think of in terms of disputes that associations might face are with their vendors. And, if you're running a community, you're dealing with the pool cleaning contractor, you're dealing with maintenance service providers, housekeeping, landscapers. You're dealing with your property manager or managing agent through a contract. And so there are lots of other individuals and entities you're dealing with on a regular basis in maintaining and operating the association and the association's property. And so getting into disputes with vendors is very common as well. And the final thing that I think about, which probably is maybe even less obvious to association board members, is employment law disputes. If you're a larger association in particular, it's very likely that you're going to have employees on the association's payroll, whether that's a general manager that lives in one of the units on property, or security staff or front desk staff. These are employees typically of the association, and therefore, at some point in time, it's likely that you may have an employment-related dispute on your hands. And so knowing how to, you may not know how to navigate the intricacies of any dispute that might arise in any of these three kind of general areas. And that's why you have legal counsel to help you. And we'll talk about that today. But, understanding kind of that these are the areas that may require some of your attention as a board member or a property manager is important, because it's kind of the first step in readying yourself to understand where do we go from here and how can I effectively address these types of situations. So that's kind of how I generally think about areas that disputes tend to arise for condominium associations.
Yeah, so for association legal counsel, usually has to work with a representative from the association side. Could be a board director, or could be, a property manager. That would be the client point person to, working together towards a problem solving for association. So when, someone, either a property manager or a board director, is designated as that point person, as an agent or like a fiduciary for this association, what would be the best practice for someone in that role to function properly in that role, to make sure you're, adding values and you're doing the right things towards, problem solving for the association in the right way?
Well, it's a great question. And I think that, it's true what you said. In my experience, there is going to be a point person. Typically, that's the board president, but it could be someone else. It could be that the board designates someone within the managing agent's office to be the kind of the point person for decision making, or to at least to relay decisions. But I think it's important for that individual, or whether it's one or two individuals who have been designated to understand these things. But I think even more broadly, that if you're serving on a board, whether it's a 5-member board, a 9-member board, a 15-member board, depending on the size of your association, even if you're not the spokesperson, I think that the things that we're going to talk about are true. In that, if you're going to be serving in this role and being not just the mouthpiece for an association, but being a decision maker or helping make decisions, it's really important for you to understand what your obligations are. And so I think one of the things that maybe, if you're a new board member coming on, that may not be obvious to you, is that you got to be familiar with the association's governing documents. And maybe you don't even know what I'm talking about when I say governing documents, but every association typically, from a condominium perspective, is going to have a declaration of covenants and conditions which prescribe various restrictions and obligations that condominium owners and the members of the association will have, and that's a primary governing document. The association is also going to have bylaws that govern its board of directors and how the board operates and what powers the board has. And another component is the house rules, and these are rules by which the members kind of collectively agree to live by and are enforced against members. They can range from things like prescribing the weight of a pet that you're able to have in your unit, how many pets you can have, when you have to stop making noise at night. I mean, there's a lot of things that go into forming those house rules, but it is a component of what's considered to be the association's governing documents. So this is all to say that it's of crucial importance that if you're going to be serving on a board of directors for a condominium association, you need to be very familiar with these various documents. Now, the declarations and bylaws in particular are drafted by lawyers typically. And so you might be thinking, why do I need to read all this legalese? And I don't understand a lot of it. And that's okay. You don't have to understand every single word, but it's important that you try. And it's important that you spend the time to read them if you're going to serve on a board, because as we're going to talk about, the reason why it's important that you do that is that you're a fiduciary for the association if you're going to be serving on a board. And that's a requirement of Hawaii law. We're not going to go into what that really means in the nitty gritty today, because I think that could be a topic of an entirely other conversation. But suffice it to say that you have obligations and duties that you owe to the association, effectively your members, the other unit owners that, in your association, and that by agreeing to serve in that role as a board of director, whether it's the president or just any other director, you have obligations. And so knowing what your governing documents say is of crucial importance. The same thing is true whether if you're going to be the managing agent for an association, is that you're also a fiduciary of that association according to Hawaii law. Your duties are different than that of a board member, and they're spelled out in the statute. And so it's important if you're going to be managing or helping to manage an association as a property manager, that you understand that lay of the land and you understand not just the statute and what that requires of you, but your contract with the association, the scope of it, the limits of it, and to ensure that you're following that management contract to the T. And I think kind of a final comment about whether you're the managing agent or a board member is if you're going to be trying to make wise decisions about disputes and how to effectively resolve them, which is what we're here to talk about today. One thing I think that's not necessarily readily apparent or that people don't think about often upfront is kind of what kind of insurance is available to the association. Whether that's directors and officers liability insurance, whether that's commercial general liability policy, there's a plethora of different types of insurance coverages that most associations are required to have, whether by law or by contract. And from a dispute resolution perspective, it's almost always a good idea to anytime a claim is made, whether it's a neighbor coming to the front desk and making a serious allegation that may arise to a claim, whether you get a formal demand letter from a law firm, it doesn't matter. If there's a claim being made, and the definition of a claim can vary widely depending on the type of insurance policy we're talking about. But suffice it to say that you should always be working closely with your insurance agent to very early on make an inquiry about whether there's insurance coverage that might be available to assist, whether it's providing coverage for the claim itself and any recovery that might be made against the association, or at the very least to see if the defense costs in terms of hiring a lawyer to help defend the association might be covered by that insurance policy. And so, again, things that may not be readily apparent, but that we see all the time in disputes involving associations.
Yeah, I also want to just add a final comment, like confidentiality, right? If you are in that role, the other thing is you need to know like what type of things, what type of communications. If it's attorney-client privileged, you need to keep it confidential. In your role, you can speak to your fellow directors, but it's not okay for you to disclose that information to a third party, like a unit owner, not alone like opposing parties, right? That could be tremendous, have like huge adverse impact on the lawsuit, on the association's interest.
That's true. And it's a great point. And I think that that's probably something else that's just not readily apparent. People aren't dealing with lawyers in their everyday life. I mean, but if you're a board member, especially on an association that has some size, I think you'll be surprised at how often you'll be interfacing with the association's outside counsel and knowing the bounds of the attorney-client privilege and what you should and shouldn't be saying beyond the walls of the board and that its attorney is important. And so that's something that if you're unfamiliar with when you're joining a board, you should ask me, the lawyer, I'm sure whoever represents the association will be more than happy to kind of explain the bounds of the attorney-client privilege and how that all works.
Yes. So talking about options, as we all know, like if a conflict arises, there's, everybody knows about it, communication, try to negotiate. And then we all know alternative dispute resolutions like mediation, arbitration. Of course, then in the worst scenario, and sometimes it is necessary for you to go to court for heavy litigation and even involving appeals down the road. So can you, based on your practice experience, walk us through these different stages of conflict and, give us some, good tips on what can we do to accomplish efficient and cost-effective problem solving?
Sure. Well, I think that you kind of hit the nail on the head in terms of there's. Well, let me backtrack. I want to say that there's not a one size fits all for any dispute, right? I mean, we tend to think of, sometimes we get calls as lawyers that where the prospective client is asking me like, okay, well, what's the plan for this? And I have very little information about the actual dispute or the details, and so oftentimes it's an impossible question that we're asked to answer. And that's because every kind of situation is going to be different. It's going to have its own facts. It's going to have its own personnel issues. And so I want to lead off by saying there's not a one size fits all option for how to tackle a particular dispute. That being said, I tend to think of it as kind of like a downstream series of options that you have, ranging from the least formal, which is kind of just having direct communications with whoever the other side disputed party is, all the way down to the other end of the extreme, which is formal litigation in court and saying, look, we've tried talking about this, but now we have to litigate because we can't get on the same page. And there's a variety of different options in between. So starting out, I tend to, as a lawyer, my goal anyway, in representing my clients, whether that's condominium associations or management companies in particular, although as you mentioned, I have represented individuals in connection with potential claims or scenarios with associations as well. But kind of putting on my hat as an attorney for an association or property manager, almost every claim that comes in, no matter how big, my first thought is, what's really going on here? And is there a way to kind of get ahead of this now before things really go south and we find ourselves in court? Because again, going back to this idea of fiduciary, if you're a board member, you have a duty to be thinking about how to be responsibly spending the funds of the association. And there are instances where it's going to be appropriate probably to have a pretty sizable legal fee or litigation budget because the claim is so serious or the allegations are there. And again, maybe, hopefully you have insurance that will provide a defense cost for that. But if you don't, this is money that's coming out of the association's coffers. And so part of the consideration you need to have in your head as a board member is, am I spending the association's money, basically your own money and your neighbor's money, in a responsible way that puts the association's best interests at the forefront? And so because of that, it's almost always a good idea to really explore and leave no stone unturned in trying to see whether there's a solution that might present itself without having to spend a lot of money on legal fees. Maybe you don't even need to get your lawyer involved, frankly. And so, not every homeowner's dispute, for example, where a homeowner is complaining about a house rule violation or a fee that he or she received, that doesn't need to be necessarily elevated to legal counsel. I mean, it seems like maybe that's the easiest thing to do, but that has consequences financially and perhaps otherwise for the association. And so I think that really considering and taking seriously the idea that sometimes a direct negotiation with the homeowner or the vendor or whoever the dispute is, and being flexible and understanding, sure, we have these rules, we have standards by which we have to abide collectively, but examining what is the overall best interest of the association, and does this scenario lend itself to some flexibility where we can reach a satisfactory resolution with this person, again, whether it's a homeowner or a vendor, that makes sense for us going forward. Oftentimes, that's going to be the most efficient use of your time as a board member and certainly of the association's funds. Now, transitioning past that, I mean, sometimes there are just disputes where you're just not able to do that, whether it's the amount that's in dispute, the what I'll call the temperature of the other person on the other side. It takes two to tango. And if the other side is not ready to have a realistic, flexible conversation about how to resolve the dispute, you might need more formal tactics. And one of the next steps that we would typically look at as a lawyer is getting the parties to a mediation. And so I'm sure a lot of people have heard that word. Probably less people have actually gone through it. Certainly less people have gone through it in the context of a dispute involving an association and another person or party. But basically mediation is a continuation of the negotiation phase, but with a third party to help you structure it, a third party that perhaps will give you some additional insight or reality check for either side. It's non-binding in the sense that this mediator, or the person that's there helping the parties to see whether they can achieve a resolution, can't bind them to any given resolution. They're not making an award. They're not ruling on anything. They're just there to try to facilitate the parties getting to a resolution that works for everybody. And so as a lawyer, we find that that's a very typical and often successful step that can be taken. And again, typically there is a cost associated with mediation. You're getting your lawyer involved, and that has its costs. But it typically tends to be, it gives yourself an opportunity to, again, get to a resolution without necessarily having to rack up a ton of legal expenses, which might occur through more formal dispute resolution processes.
Yeah, so for mediation, I also want to chime in that, under 514B 161, there are certain types of disputes. If one party requests or demands for mediation, the association is obligated to participate in such mediation. And you can also, there is a state program providing subsidy for evaluative mediation for condominium disputes. From the Condominium Education Trust Fund, they will cover each party chip in a small portion of fees for the mediator's first hour, and then the rest subject to a cap will be covered by this program. So this is definitely, encouraged to be used. Even if there is no binding arbitration, binding mediation, parties can voluntarily agree to go into this phase, even if there's already a court action pending, right?
Right, and that's actually really common. I mean, so you're right. There are certain types of disputes in the statute for condominium associations that require the parties to mediate as an initial step. And those typically involve, interpretation of the association's governing documents, interpretation and application of those governing documents. But you're right. I mean, even in situations where the parties find themselves in a more formal dispute setting, I can think of very few situations where it may not make sense to at least try to test the waters. If both sides are amenable, are open to the idea of sitting down and scheduling a mediation, that's already a good sign. The fact that two parties or more are saying, you know what, let's sit down with the mediator and see whether we can come to some sort of resolution without going further in the fight. You're already halfway there. It shows that there's at least a willingness to think about the situation in a way that doesn't entail a polarizing win or a polarizing loss. And so the fact, if you're getting to a mediation, it doesn't, if you've gotten past that stage and you find yourself in litigation, it's very, very common to find yourself back in mediation because it is again, not doing it can sometimes be a wasted opportunity or a missed opportunity. And I think sometimes people realize that after they get to the more formal part of the dispute resolution process.
Yeah, so you think about it, it's a process where both parties can actually create this solution for your problem, which each person can live with, right? If you're not happy about it, you always have the right to say no. So ultimately, there's always a good compromise there. Yes, so let's talk about arbitration. What's the difference, compared with mediation and arbitration?
Sure. So unlike mediation, where the mediator, the third party that's assisting the parties, is not there to make a ruling or is not there to do anything that can bind the parties unless they're both agreeable, arbitration is different. An arbitrator is sort of like a judge in a private setting. Now, just like mediation, under the condominium association statute, there are certain types of disputes that you have to go through arbitration. Now, I don't want to, at the risk of confusing things, that type of arbitration in the statute typically is non-binding, and you have the option to proceed to a trial under certain circumstances if you'd like. But going back to your point, if the parties agree to go to arbitration contractually and say, look, we're going to submit this dispute to arbitration, and there are reasons why parties might do that, then that's a situation where you are allowing this third person, the arbitrator, whether it's a one person or a 3-panel arbitration panel, to say, we want to submit the dispute for your consideration in acknowledgement that we can't come to the resolution ourselves, and we'd like you to make a decision that's going to be binding. Most times you can agree to binding arbitration, binding on the parties. The thinking with arbitration historically was that it's a way to get to a quicker resolution. Historically speaking anyway, in the court systems in Hawaii and elsewhere, I mean, it would take many, many months, if not, a couple of years to get to a trial. And the thinking was that if we can save the parties the time, the expense, the heartache in having to wait these 2 years to have their situation resolved, that's a good thing. And so arbitration remains an option. It is different in the sense that someone's going to be making a decision that binds you, and there are appeal implications that we won't go into. But I want to make sure that we kind of transition to the next step, which is if you find yourself having exhausted all of these potential options, there's the reality that you might find yourself in court, whichever side you might be on, whether it's association, you're bringing in a claim for unpaid maintenance fees against a unit owner, or you're defending against a claim by an employee who's making an employment discrimination claim. There is a potential that you're going to find yourself in litigation. And I always tell people that that's definitely should be your, I don't want to call it the worst case scenario, but it's your least desirable option. And you should make sure you exhaust all other options beforehand. And I say that because it's such an expensive and risky process. You might think you have a great case or a great defense. The reality is that as soon as you're in litigation, you take it out of your hands and you put it in the hands of whether it's a judge or a jury. Someone else is going to be deciding whether you're right or wrong and what the implications of that are. And I also tell people that litigation is kind of like pushing a snowball down a hill. It starts off really small. It tends to pick up a life of its own. It gets bigger and bigger and bigger. And at some point, you might not be able to stop it even if you wanted to. And so that's a big consideration up front before people launch off into that realm.
So that's the cost-benefit analysis we always wrestle with as legal counsel, right? So our time is almost up. So can you help us, summarize our takeaways for our audience today?
Sure. And I don't know that if I'll be summarizing what we said. We talked about a lot, and I'm sorry if I kind of was rambling, but in terms of just takeaways and best practices for especially new board members, I would say communicate early and often. That's your best friend, whether that's with your attorney, whether with homeowners. The more I would say over communicate if possible, so that there's transparency all around. Financial responsibility is paramount. Understanding your role in making decisions for the association's funds is key. And then finally, I always recommend that this is not legal advice, and we're not trying to do that here, but just be reasonable and understanding that you're living in a community with your neighbors who are members of the association too. And there's an incentive to try to get along and get to the end of a dispute as quickly as possible.
Thank you so much for your time today.
All right. Thanks, Na. Thanks for having me.
Thank you so much for watching Think Tech Hawaii. If you like what we do, please like us and click the subscribe button on YouTube and the follow button on Vimeo. You can also follow us on Facebook, Instagram, and LinkedIn, and donate to us at thinktechhawaii.com. Mahalo.